Let's talk about something you don't see every day in a courtroom. We're diving into a fascinating and pretty intense legal showdown where a former chief minister, Arvind Kejriwal, has asked a high court judge to step away from his case. This isn't just a legal maneuver. It really gets to the heart of what we expect from our justice system.
And this quote from the judge herself, Justice Swarana Kanta Sharma, really says it all. I mean, it's so candid. For the first time, she says, it just shows you how unusual this whole situation is and sets the stage for a high-stakes drama that's all about the appearance of justice.
All right, so here's our game plan for breaking this all down. We'll start with how this whole thing kicked off. Then we'll dig into the specific reasons for the recusal request and, of course, the arguments against it. After that, we'll look at the law actually says, and we'll wrap up with the big central question this whole case leaves us with.
Okay, first up, let's get into the timeline. How did we even get here? I mean, what leads a senior politician to make such a bold and direct request for a judge to step aside? You really have to see the sequence of events to get it.
So check this out, it all happens pretty fast. On February 27th, a trial court basically says Kejriwal and the others are in the clear, case discharged. But then, and this is the key part, just about a week later, Justice Sharma steps in and hits pause on that whole thing. And she does it ex parte, which, just means she did it without hearing from Kejriwal's side first. And that move, that's the spark that lights the fire for this whole recusal request a month later.
All right, let's get into the nitty-gritty. What were the actual arguments? Because Kejriwal's lawyers didn't just show up and say, this doesn't feel right. No, they came prepared with 3 very specific legal arguments, all pointing to something called apprehended bias.
The very first point was all about ideological alignment. This one centered on who the judge was seen with publicly. Kejriwal's team brought up the fact that she'd attended events organized by a group called Adivakta Parishad, which is a lawyer's body linked to the RSS.
And here's Kejriwal himself putting it in his own words in court. He's saying, look, you've gone to their programs 4 times. I'm on the complete opposite side of the ideological fence. How can I believe I'm going to get a fair shake? It's all about the impression it creates for him, the person whose fate is being decided.
Okay, argument number 2, the speed of it all. This goes right back to that March 9th decision we talked about. The argument here is that the sheer speed of that decision, pausing the lower court's ruling, well, it felt a little off. And again, listen to how he puts it. He's basically saying, I was shocked. The trial court took 3 months to come to its decision, and then, poof, the high court declares it erroneous in just 5 minutes? You can see why he's arguing that would create what he calls serious apprehensions.
And now for the third point, which honestly might be the most pointed one of all. This one came up a bit later in a separate filing, and it's all about a potential conflict of interest, hitting very close to home for the judge.
Okay, let's unpack this, because it's a big one. So the judge's son and daughter, both lawyers for the central government. And who allocates their legal work? The Office of the Solicitor General of India. Now, who's the Solicitor General? Tushar Mehta, the very same lawyer arguing for the CBI in this exact case. You see the connection? Kejriwal's team was super careful to say, hey, we're not alleging any actual bias, but the appearance of a conflict of interest here is just undeniable.
So that's one side of the story. But you can bet the Central Bureau of Investigation had a lot to say about all this. The Solicitor General, Tushar Mehta, came out swinging, basically arguing this whole thing was just a legal tactic.
Remember that first point about the judge attending those events? Well, the CBI's response was basically, so what? They said it wasn't some secret ideological meeting. It was a legal seminar organized by a lawyers group. The kind of thing judges go to all the time as part of their job. Standard procedure.
And yeah, the Solicitor General did not hold back. He called the argument juvenile. And then he dropped this little bombshell. He pointed out that Kejriwal himself had gotten bail from another judge who had also attended events by that very same organization. He was really trying to pull the rug out from under that whole line of reasoning.
So the CBI's main accusation? They called it forum shopping. That's a legal term for when someone tries to game the system to get their case in front of a judge they think will be more friendly to them. Basically, trying to pick your own referee.
And Mehta really went for it. He said this wasn't just about one case, it was a mollified attempt to attack the whole system. He warned that if judges start recusing based on these kinds of claims, it would set a terrible precedent. Any litigant could just sling some mud, try to malign the bench, and get a new judge. He even suggested the court should consider contempt of court action. a very serious counterattack.
Okay, so we've heard both sides go at it, but what does the law actually say about all this? Because this whole debate comes down to a really important legal idea that's all about protecting the court's integrity. Let's dig in.
So, what is recusal? It's pretty simple, really. It's when a judge decides to step away from a case to avoid even the perception of being biased. It's all about that classic saying, justice mustn't just be done, it must be seen to be done. And importantly, in India, it's ultimately the judge's own call to make.
Now, this is probably the most important part to understand. The whole legal test isn't about asking, hey, judge, are you actually biased? That's the wrong question. The right question is, would a regular, fair-minded person looking at all this think there's a chance the judge might be biased? It's all about perception, not proof of actual bias.
And this isn't some newfangled idea, not at all. This standard was set way back in 1987 in a landmark Supreme Court case. For decades, the law in India has been crystal clear. What matters is whether the person in the case has a reasonable fear of bias. It's their perspective, their apprehension, that's at the center of it all.
So all of this brings us to the real dilemma, doesn't it? The fundamental standoff at the heart of this case. You've got these two core principles of justice, and they're pulling in opposite directions.
It's like this. On one hand, a judge has a job to do. They have a duty to hear the cases put in front of them, no matter how tough or messy they are. But on the other hand, the whole system only works if we, the public, believe it's fair. If that appearance of fairness gets cloudy, the whole system is in trouble.
And that leaves us with a really tough question. We all know that old saying, justice must not only be done, but be seen to be done. But in today's world, with polarized politics and intense media scrutiny, who gets to decide what that seeing actually looks like? And where does a judge draw the line to maintain not just their own impartiality, but our unwavering faith in the entire system? A lot to think about.